What rights should pertain under the claim of right if the Union were really in place, shaped by the treaty that created it? It's impossible to illustrate all of them here, but two fundamental and astonishingly progressive provisions of the claim of right should serve. Let's begin with one which challenges the recent use of terrorism law by the UK government to proscribe a non-violent, direct action group, Palestine Action, when this prescription contravenes international norms, as Volker Turk reminded Prime Minister Starmer only a few weeks ago, to no avail. And today, anyone in the UK who directly or indirectly expresses support for the proscribed group is liable to arrest, as over 1,000 people can tell you. At the same time, the United Kingdom government has provided moral and practical support to the State of Israel, so it is clear that its reinterpretation of terrorism law in direct contravention of that law's stated purpose and of the guarantees that it would never be applied in this way is purely political. But this is not only internationally wrongful. Under the claim of right, such abuse is specifically prohibited in Scotland. I told you it was progressive. Clause 6 of a list of prohibitions within the Claim of Right Act states that the law may not be perverted into an instrument of political persecution. No government, magistrate, court may pursue, convict, or remove the liberty or property of any person by stretching or interpreting the law beyond its true intent and purpose in order to criminalise political opposition or dissent. Was this clause part of the condition of the Union respected by the United Kingdom government? It was not even raised as an obstacle to the bending of terrorism law for political ends. But if it's a fundamental law and still in force, it is on the statute books, then surely Scots can apply it to challenge the criminalisation of dissent. To raise it at all is to oppose the colonial doctrine of parliamentary sovereignty, the absolute authority assumed by England's Parliament under pre-Union English law to make or unmake any law it chooses. In Scotland, government is limited by the rights of the people. In England, the Parliament has the authority to make or unmake any law it chooses. Where stand then the rights of the people or the human rights that are recognised in international law? But to challenge this is something few in the legal establishment of Scotland or England are ready to attempt. And to successfully assert the simple and unquestionable fact of this guarantor of civil liberty is a near impossibility. Doesn't mean we're not going to try. Because we are not in a partnership. The terms of the partnership agreement were long ago discarded by England, and no one, either within or beyond its domestic circle, has so far found a way to challenge this breach. Moving from civil rights to assets and resources, we find territorial dispossession, the administration of Scotland's oil and gas, the disposal of territorial assets, and the redirection of its renewable energy to supply the English domestic market, among many other examples, demonstrating the reality of Scotland's status. How does this show in law? Well, because no united crown was ever created, no British crown exists, the Crown of Scotland remains as a legal and constitutional reality. Now, it's important to know something about the Crown of Scotland. In most monarchies, the Crown is the monarch. In Scotland, it is not. In Scotland, the Crown, the sovereign authority, is the community of the realm or the people. How radical is that? How progressive is that? And yet it's an ancient provision. The claim of right protects the Scottish Crown by making it a requirement that the Scottish coronation oath remains in force, that it must be taken. And this oath also remains on the statutes because it is protected by the Claim of Right Act. Within that oath is a promise that any monarch must take to be lawful monarch of Scots, to defend and never transfer the rights of the Scottish Crown. And so, because our Crown remains, Scotland retains its territorial sovereignty. It is recognised as a stateless but sovereign territorial nation. The territory of Scotland remains legally vested in the Scottish Crown, which is the people. And so, legal title to the territorial and maritime assets of Scotland resides with the Scottish people, not a monarch, not a government, and not a parliament.